Good afternoon, everyone. Welcome to the Appellate Division, First Department. Today we have some 7 hours of argument that has been requested, so I'm going to ask that you bear that in mind as I call the calendar, and remember that we have your briefs, we have the record, we're fully familiar with the facts of your case, so please only ask for the time that you will need in order to make your most important points. First case is People versus Ramon Almonte. 5, 1, and 5, thank you. Carrito versus Onyx Realty. Counsel, the petitioner is not here. You don't want to argue against yourself?
No, I'm submitting.
Submitting, okay, thank you. Tristan R. is submitted. Lent versus the City of New York.
Good afternoon, Your Honor.
I'm sorry, I didn't hear you.
Request 10 minutes on argument.
6 and 2 and 6. Saunders versus Fauci. I'm sorry, Fauci. You want to submit? I don't see petitioner. So submission. Thank you. People versus Jaquan Coleman. 3, 1, and 3. Thank you. People versus Tavares Gaston. Submitted. 17 York Avenue versus New York State DHCR. Good morning, Your Honor. Good afternoon. 5 and 2. Respondent DHCR request 3 for all 4 cases. I'm going to have everyone stand on this. 160 East 84th Street. Are they here? You're representing everyone, right? 87th Street, Sherry and Claremont, York, all against New York State Department of DHCR. Why don't you tell me the amount of time that you want for all 4 cases, and we'll do it that way, okay? Okay, 5 and 2 on everything, and 3. Okay, great. Thank you very much. People versus Andrew Kaforji. 5, 2, and 5. Eccles versus Shamrock Capital. Good afternoon, Your Honor. The 2 groups of appellants together asked for 8 minutes and 2 on the 8 minutes and 2 on the 1. I'm sorry? So you're going to split the time between, or is just one? And on your side, are you splitting the time? Yes. How are you splitting the time? I don't think you need, okay, 5, 8 and 2, and you asked for 8. 8 and 2 and 8. People versus Juan Rivera. 4, 1, and 4. Moy versus the City of New York was withdrawn by stipulation. Tantalon Austin Hotel versus Wilmington Trust. 5 and 2 and 5. Cardinale versus Avalon West Chelsea. Um, 5 and 2, 3 and 3. Thank you. 5 and 1. I'm sorry. 3 and 3. People versus Ramal Robinson. Submitted. People versus Theodore Simpson. Submitted. Pignato versus EQR River Tower. I'm sorry. Submitted. Rector versus BDG Gotham. Submitted. Bass versus WV Preservation Partners. Submitted. The first case for argument is People versus Ramon Almonte.
They're not arguing. They're not arguing. Oh, no.
Good afternoon, Your Honors. May I begin?
Yes.
Katrina Jean Myers from the Office of the Appellate Defender for Mr. Ramon Almonte. Mr. Almonte's sentence should be reduced because his criminal conduct was the result of his addiction to heroin. The surveillance footage captured in this case depicted Mr. Almonte falling asleep, unable to speak, and unable to function while he was high selling heroin in the lobby of a building. His family acknowledged his addiction in writing to the sentencing court and described him as a vibrant and nonviolent man. Mr. Almonte also wrote to the court and spoke at sentencing. He acknowledged the impact that his addiction and criminal conduct had on the court, his community, and his family, and is hopeful to have a drug-free future. Given Mr. Almonte's expressions of remorse, as well as his family support, Mr. Almonte has a very low risk of recidivism. Given these mitigating circumstances, there was no reason to increase Mr. Almonte's sentence beyond what was initially offered to him, and in fact, to offer him more time than that of his co-defendants.
Well, could you address that? Was there a disparity in the sentencing here?
Yes, Your Honor.
how?
Go ahead, Your Honor, I'm sorry.
Go ahead, go ahead.
Mr. Almonte's aggregate sentence is greater than that of the operation's ringleaders, who were convicted of conspiracy in the second degree and operating as major traffickers. One of them received 5 to 10 years on the conspiracy charge and 11 years for operating as a major trafficker. The other received 3 to 9 on conspiracy and again 11 on the trafficking charge. These are charges, or convictions, I should say, that mean that someone was found guilty of moving.
What did it mean when they turned to the defendant to stretch out the cocaine supply?
The two ringleaders of the operation had a conversation between each other about directing Mr. Almonte to stretch out the supply of cocaine. Mr. Almonte was not in the conversation. He was not on the telephone. There's no indication that the operation's ringleaders...
Is there any indication why he was the one? I mean, this was a big operation, wasn't it? Is there any
Correct.
indication why he was the one that they chose to be the one to stretch out the cocaine supply?
There's no indication that he was chosen to stretch out the cocaine supply. What the record indicates is that the ringleaders had a conversation about asking him to do that. Their record does not demonstrate that that actually occurred. And it's also reflective of Mr. Almonte's position within the criminal organization. He was a street-level dealer. He worked underneath individuals who carried and held the drugs and money in a stash house, individuals who then delivered it to supervisors on the street, who oversaw lookouts, who directed people to Mr. Almonte's location, and that of the other 8 or 9 dealers in the case who then conducted the sales.
Mr. Almonte has another conviction in another state. Was that just in 2011?
That's correct.
For controlled substance again?
That's correct. And that conviction...
Is there any conviction that involves violence or a weapon?
No, Your Honor. His conviction in New Jersey was for possessing a controlled substance and was factored into his sentence and is very indicative of his history of addiction. His criminal history record reflects his struggles. And given the fact that he has his family's support, This is his first time serving a lengthy prison sentence. When he's released, he'll have to serve 3 years of PRS. He has a very high likelihood of successfully entering the community upon his release. Sentencing him to the initial offer, or reducing the sentence to the initial offer, would be a just exercise.
And would you just remind me what the initial offer was, please?
The initial offer was 5 years flat on the sale charge and 5 to 10 years on the conspiracy charge. We're going to ask for 5 to 12 and a half on the conspiracy charge, Your Honors.
And he was sentenced to 7 to 14.
And he was sentenced to 7 to 14, correct, and 8 years flat on the sale charge. So that's 3 additional years on the sale charge that he will have to be incarcerated, which is a very lengthy amount of time that is not necessary to impress upon him the gravity of his actions, given his expressions of remorse, given his family's support, and how voraciously he expressed his contrition to the court at the time of sentencing and in writing. He's truly a victim of the opioid epidemic. He has been struggling with addiction to heroin for a 10-year period of time. He has been incarcerated and is now clean. He deserves a chance to move forward with his life. And the 3 additional years of imprisonment, given that the ringleaders of the operation who exploited his addiction and had him work on their behalf received practically the same time. Thank you, Your Honors.
Thank you.
May it please the court, Brent Yarnell for the people. It would totally undermine the plea bargaining process to give defendant the very same sentence that he twice rejected, not once, but twice. With regard to the co-defendants, it's important
So it wouldn't have anything to do with the value of the case. It would simply have to do with the fact that he didn't make the wise decision initially.
I don't agree. I think that the sentence here was warranted given the seriousness of defendant's crime. He was...
Well, presumably the first offer he got was as well.
Yeah, look, I mean, I think it's a typical part of the plea bargaining negotiation that the people are willing to offer.
When did he take this plea?
He accepted the plea on August 6, 2018, which was about 6 months after...
No, I don't mean, what was going on in the case when he took the plea?
So what was going on in the case was that defendant and the people were in the court at the beginning of a Wade hearing, which basically laid out all the surveillance footage that the people had showing the 53 cocaine sales that defendant executed.
All 53 sales were on video?
I'm sorry, would you repeat the
All
question?
of the 53 sales were on video?
I don't know the answer to that. I know that that there were...
He was selling in the lobby of a building. You must have had that on video.
Yes, selling in the lobby of the building, 53 sales. 9 of the sales were to undercover officers. So the evidence against defendant was extremely substantial.
But it was the same when you offered him the plea initially, right? You had that evidence. Am I correct?
We had the evidence at the
Okay,
time.
and my next question is, he pled guilty after the Wade hearing or during the Wade hearing? There was no jury involved, no trial involved. Am I right?
He pled guilty after the Wade hearing. You know, look, it's important to note here, first of all, he did play an integral role in this major drug conspiracy. He was the front, public-facing, customer-facing part of the organization. And
does he have any crimes of violence in his criminal history?
Well, he didn't have crimes of violence, but his crimes weren't victimless. He had 2 convictions for petite
Well, when I
larceny.
ask about violence, I'm talking about guns, weapons, hitting anybody over the head, and any sort of violence. I think you know what question I'm asking. Is that a no, there aren't?
Yeah, I answered no, there aren't crimes of violence, but that doesn't mean that his crimes were victimless, and it's important to note that his...
I don't think any crime is victimless, frankly, but...
Well, I'd agree with that. And I think that it's important to note that his criminal history shows that he has a repeated history of being given a second chance and not taking that second chance. So on his 2011 felony conviction in New Jersey, he was given a sentence of probation. That probation ultimately had to be revoked. In 2014, he was sentenced for petite larceny. 3 months later, after pleading guilty to petite larceny, he was arraigned again on petite larceny.
Is there evidence that he has a drug problem?
Well, he stated that he has a drug problem, and then he has his letter from his mother's and his aunts.
Was there
saying that-
any evidence on the video that he seemed to be under the influence of drugs at all?
I haven't reviewed the video. He claims that in the
You
video.
didn't review the video that this, with the 53 or whatever it was, the evidence here?
I'm sorry, Your Honor?
The video is the evidence in this case. You didn't review that?
Well, the video is the evidence in addition to what would be witness testimony from the undercover officers who executed these trades with defendant. And I think, it's important to note that, even if his drug addiction might have contributed to his decision to sell drugs, he still bears responsibility for that decision. I mean, he sold, over a 16-month period, he sold cocaine 53 times. He was an integral member of this organization. The stretch out the supply comment is important because it shows that Omar and Jose Luperon were relying on defendant to exercise some judgment and make some decision-making capabilities. I mean, stretching out supply is something that, I personally don't know how to do. So if you are relying on someone to do that, you're relying on someone to make some decisions about how exactly they're going to do that. Those decisions do have consequences because they affect the product that you're giving to your customers. It's effectively a business decision. And the fact that, yes, Your Honor.
Counsel, if I'm not mistaken, the ringleaders, the Luperon brothers, actually got a greater sentence on the sale charge, correct?
Well, they didn't have a sale charge. They got 11 years.
11 years, where he got 8.
He got 8. They got 11 years.
Correct.
They both pled guilty 6 months before he did. If he had pled guilty at that time, he would have received a sentence of 5 years on the sale charge, which would have been 6 years less than the determinant sentence they had gotten. So if he had pled guilty at the time they pled guilty, his determinant sentence would have been 6 years less than their sentence.
And is it possible that they got a lesser sentence on the conspiracy charge because the defendant here did more overt acts as being the person on the ground than they?
Absolutely, Your Honor. Defendant committed 57 overt acts in the conspiracy. Omar Luperon had 25 overt acts. Jose Luperon had 25 overt acts. So that's absolutely, you're right. And I think the critical point is that if he had accepted the offer at the time that they pleaded guilty, his determinant sentence would have been significantly lower than theirs, and it would have been exactly the same sentence as Tyreek Anderson's, who's the one member of this conspiracy who basically had a similar role to defendants, although he actually had less sales. So he was a lesser role, but he was a seller too. And I think just that fact and the fact that they're up here asking for the very sentence that we offered, the fact that they're asking for the very sentence that we offered just shows that the process here was totally fair and should not be disturbed. We ask that your honors affirm. Thank you.
Thank you.
Thank you, Your Honors. To answer Your Honor's question first, the Luperons were sentenced to 11 years for operating as a major trafficker, which is different than criminal sale of a controlled substance. Someone's convicted of operating as a major trafficker when they run a drug trafficking operation that requires them to conduct over a year of sales and make over $75,000 in proceeds. And one of the Luperons was arrested with over $160,000 in cash on his possession. Yes, Mr. Almonte is responsible for conducting more sales on the street, but that's very indicative of his role in a large drug trafficking organization. As your honors are well aware, higher-ups in drug trafficking organizations try to shield themselves from criminal liability by having low-level dealers do the dirty work for them and expose themselves to the police, to arrests, and to everything bad that happens when someone sells drugs.
Counsel, with which co-defendant was your client most similarly situated?
Your Honor, I'd say my client was similarly situated to Mr. Tyreek Anderson, who is also a street-level dealer. He was convicted of criminal sale of a controlled substance and conspiracy in the second degree. He was given 5 years flat on the sale charge and 5 to 10 years on the conspiracy charge. Also, Mr. Edward Adams, he pled guilty to conspiracy in the fourth degree, so that's not comparable to this case. However, he received 2 years flat on the sale charge. So that's a 6-year difference from what Mr. Almonte faced. And if there are no other questions, Mr. Almonte asked the court to reduce his sentence to 5 years flat on the sale charge, 5 to 12.5 years on the conspiracy charge. Given his history of addiction that's very documented in this case, his family support, low risk of recidivism, expressions of remorse, as well as his minor role in the conspiracy, it would be a just exercise of this court's discretion. Thank you very much.
Thank you. Thank you both. Lent versus the City of New York.
May it please the court. Edward Tobin on behalf of the plaintiff appellant, Thomas Lent. Plaintiff appellant respectfully submits that the lower court erred in granting the defendant's motion to dismiss the complaint in this action. With respect to several arguments raised by the respondents in their brief in opposition to our appeal, I'd like to address arguments that they made, if the court permits. The respondents allege or state that plaintiff appellant miscategorized what the pleading standard is. As the court is fully aware, the pleading standards, all inferences are to be given to the plaintiff based upon the four corners of the complaint. And the appellant respectfully submits that sufficient facts were alleged.
So, counsel, getting to that point, what are the facts that plaintiff has alleged with respect to an adverse employment action?
With respect to the adverse employment action, it is the assignment of ministerial and minimal duties and the transfer.
Oh, but that's the one with the New Jersey incident where he was arrested?
But with respect to the New Jersey incident where he was arrested, he was cleared of all those charges.
But he was arrested, correct?
He was arrested and then subsequently.
Well, what does that suggest if he was arrested? That there was probable cause for the arrest?
Well, as the facts so point out, it was a dispute with his ex-wife, and she later recanted.
Was it a dispute or was it domestic violence?
It was an allegation of domestic violence, and the wife later recanted it, and he was fully cleared of all charges.
Well, he was cleared, or the case was dismissed because it didn't proceed to trial?
She recanted, and the record supports that he was cleared of all charges, and the case was dismissed. If I may continue. The respondents further argue that a hostile work environment can be analyzed identically to discrimination claims. Appellant respectfully submits that there are two separate standards there, and with respect to the hostile work environment claim, a work environment would be considered hostile if a reasonable person would have found it to be so and if the plaintiff subjectively so perceived it. When evaluating a claim for a hostile work environment, a court should consider whether the workplace is permeated with discriminatory intimidation, ridicule, insult, and that it's sufficiently severe or pervasive as to alter the condition of the victim's employment. Here, where a direct supervisor was involved, in the work situation, sufficient intent for a hostile work environment can be attributed.
You're talking about McDonald now?
Yes, I'm talking about
So
McDonald's.
what specifically did McDonald do that resulted in a hostile work environment?
Well, the comment that McDonald made with respect to you're old enough and you should retire, I'm paraphrasing to a certain extent.
So was that one comment? Was that a continuing theme that she would raise with the plaintiff?
As alleged in the complaint, it was one comment. However, the case law sufficiently reflects that one comment can be enough to insinuate or demonstrate an adverse a hostile work environment and adverse employment condition.
Well, what evidence is it that the conditions that he complains of was actually tied to that statement and not to the fact that he had been suspended as a result of the domestic violence arrest?
It's a temporal argument, Your Honor, and that he was assigned the ministerial duties and transferred to the Viper unit, I believe after he was cleared of all charges, or once he was cleared of all charges, he was not reinstated to his initial position.
Well, he was cleared of charges regarding the arrest in court, right? Not with regard to any kind of investigation that the police department would have made.
He was cleared of all charges, and yet, if you look at the comparators, I believe it was Koppel, she was subject to domestic violence charges, and she was not cleared, yet she was not transferred, and she was not.
Was there any evidence that she had physically assaulted anyone, or that she had instigated it, or that any other facts to clarify that?
Based upon our knowledge and the plaintiff's knowledge, it was domestic violence, and there was a charge made.
Was there an arrest?
I believe there was, yes.
I'm sorry, you believe there was
I
an
believe
arrest?
there was, yes.
Well, is there an allegation in the complaint that there was an arrest?
There was a complaint made, and I believe the complaint states that based upon the plaintiff's knowledge, an arrest was made, but however, it's upon information and belief.
So information and belief, okay.
Counsel, separate from potential overtime opportunities and putting aside the arguable inconvenience of having to travel, what you called road therapy in your papers, did your client lose rank? Did he lose his salary? Did he lose pension benefits? He didn't lose any of that, did he?
It's part of a pattern of discrimination based upon age and an attempt to force him.
But understand it, when we're talking about circumstances where someone, because of discrimination, could be demoted.
With respect to...
He didn't lose his rank. He was still a lieutenant, correct?
Correct. But with...
He didn't lose his pay. In other words, he didn't have... While you argue that he could have made overtime and had certain opportunities, and I'm not making light of that, his base pay and all the different soft dollar benefits that went into his remuneration was not diminished in any way.
But as a practical matter, police officers in the city of New York depend upon overtime pay, and there's more overtime is allotted to those with sufficient seniority, and the fact that he was assigned to road therapy was a deliberate attempt to reduce his pay and reduce his yearly income, and it did have the required effect.
Thank you.
Thank you very much.
Good afternoon, Your Honors. John Shep-Wong on behalf of the city respondents. May it please the courts. No reasonable view of this complaint adds up to a claim of age discrimination. And I'd like to start with the allegations of discriminatory animus.
It is a pleading motion, and when you look at all of the things which are alleged individually, they really are not sufficient, but when you put them all together, this transfer to the Viper unit, the fact that he's only given Mondays and Tuesdays off while other people are given weekends off, the investigation that's launched against him because of an incident with the sticker in a parking situation. But when you put all these things together, doesn't that support, in terms of 3211, doesn't that support his claim?
Well, it sounds like Your Honor is addressing the adverse employment prong, so we can discuss that one first. So I have two responses to that. Number one, the only two adverse employment actions that the plaintiff sufficiently challenged in this case were the Viper allegations and the sticker allegations. All of this information about the a joined view that came out mostly in the replies. So I would submit that only those two are worthy of this court's attention. Number two, we also have to consider whether any of those actions were tied to any decision maker that expressed any sort of discriminatory animus, any sort of reasonable inference of age discrimination. And I submit that that doesn't exist in this case. With the Viper allegation, there's no allegation in the complaint that Inspector McDonald was involved in the decision to transfer him to Viper. He alleges...
But there's an allegation that she essentially said he's old enough to retire. Would that support... at least with respect to the discrimination, age discrimination claim?
No, Your Honor. I submit that it doesn't support a reasonable inference of age discrimination. It's entirely speculative. There's nothing about that one comment that suggests any sort of bias based on age. It doesn't suggest that...
Well, generally, you're a certain age, you can retire, so that suggests that he's of an age he can retire. I assume that's what's the intent of the comment, right?
That is a factual statement, that he is old enough to retire. That is, there's no dispute that, the complaint alleges that...
How old
He was 43 years old at the time of the 2018 allegations. He was 45 years old at the time that he filed this complaint. And I would just ask this court to look at the context, look at what Inspector McDonald actually said, and look at the context in which it arose. I think that, respondent cites, or the appellant cites a number of cases in his reply with regard to one single comment being enough. And in all of those cases, there was more than something like this. There was explicit derogatory references. There were repeated references to age. There was conduct that expressed discriminatory intent. And that's not what we have here. What we have here is one comment in a conversation about a domestic violence dispute, about charges, and I would also note that I think that the complaint does not state that the ex-wife recanted her allegations. It does not state that at all, and I would just point, Your Honors, to paragraph 17 of the complaint where he talks about how the charges were dismissed. There's nothing about why the charges were dismissed, and I would just emphasize that the charges being dismissed, charges in criminal cases can be dismissed for any number of reasons, as Your Honors know. The standard for a criminal dismissal is not the same as the standard for an employment decision that the NYPD is entitled to make. The NYPD is conducting its own investigation, according to the complaint, into these allegations, and they are not bound by what the determination in criminal court was. We don't know if it was dismissed for a procedural reason, we don't know if it was dismissed for a substantive reason, and we certainly don't know that it was any sort of recanting by the ex-wife, because that is not at all in the complaint. So nothing about this single comment evidences age discrimination, and I would just ask the court to focus, to look at the complaint's allegation itself. The complaint's allegations themselves demonstrate that this was a comment based on her belief, based on her belief that maybe he shouldn't be a police officer anymore, but not because of his age, but because of these accusations of domestic violence, and believing that a police officer shouldn't be a police officer anymore if they've been criminally charged is not age discrimination.
How can we make that decision on a pleading motion? I mean, maybe summary judgment where she's been deposed?
I think that we can make that determination because the standard for CPLR 3211 motions is whether a reasonable view of the facts supports an inference of age discrimination. And I think that any inference of age discrimination here is entirely speculative based on how this comment arose, because it's not derogatory on its face, and it was clearly, as alleged in the complaint, it was part of this discussion about the domestic violence charges.
Sir, at least with respect to the city human rights law claims, under VIG, isn't the standard a little more lenient? Isn't it simply whether the defendant has fair notice of the claims?
So, Your Honor, I think that VIG does state that it's a notice pleading standard, but the way that this court has applied the notice pleading standard, this court has always looked to whether there are concrete factual allegations that support a reasonable inference of discrimination. It's not just that we know this is an age discrimination complaint. That can't be enough. Otherwise, it would just completely nullify 3211 claims. There would be no motion to dismiss standard. If all that a complainant had to state was the literal elements of the complaint, which I think is...
I agree with you, but this was a 19 or 20-page complaint, and it spelled out a variety of specifics. So it's not a matter as if you got a summons with notice saying I'm pleading, I'm alleging city human rights law violations. There was meat on the bone, so to speak.
I would dispute that, Your Honor. I don't think there's meat on the bones here, because what we have are this one comment, and then we have comparators who are not at all similarly situated, and those comparators were not accused of the same sorts of misconduct that the complainant in this case admits that he was accused of. So I would submit, Your Honor, that there isn't a meat on the bones when you look at this from a standard that looks at the concrete factual allegations to see if this rises above a level of speculation with regard to discriminatory animus, Your Honor. I see that my red light is up. Thank you, Your Honors. I would rest on my brief for the rest of the arguments.
Thank you.
Briefly in rebuttal, Your Honor, with respect to the sticker incident, he argues that a supervisor was not involved in that incident. It was Lieutenant who was that ordered the BAT sticker issue. They claimed that it was unconnected to McDonald. However, they failed to address the arguments in our briefs that the lieutenant reported to McDonald, and then that McDonald ordered Lent to investigate that. With respect to the domestic charges in the dispute, It's appellant's position that that is a proper subject of for discovery, and that should be addressed on dispositive motion practice,
Are
summary
the-
judgment practice.
The claim with respect to the woman, I think, the police officer who was also allegedly engaged in some kind of domestic violence, are they similar claims?
It's my understanding that they are, and all that'll be addressed during discovery. And that's a proper foundation for a motion for summary judgment and not for a motion to dismiss. As the court pointed out, this is a 20-page complaint. There's sufficient meat on the bones. And if you take a look at the incidents as alleged, constitutes a pattern, the totality of the circumstances is sufficient to survive a motion to dismiss in this action. Thank you very much.
Thank you both. People versus Jaquan Coleman.
Just wait for my adversary to get settled, if that's, yeah, of course. Good afternoon, Your Honors. May it please the court. Cara Labini for Jaquan Coleman. A sentence reduction is the just and appropriate outcome in this case because Jaquan was just 16 and 17 years old at the time of the instant offenses. He had no prior convictions. Supreme Court jurisprudence as well as scientific research has highlighted that an adolescent's brain is not fully mature, far from it, especially in the regions dedicated to controlling emotions, risk avoidance, and decision-making. So for the majority of teenagers, risky conduct terminates with age. That's why the Supreme Court found in Miller versus Alabama that the actions of adolescents, like those of Jaquan in this case, are less likely to be evidence of irretrievable depravity. Compounding that scientific background with Jaquan's particular personal background, he was experiencing an especially turbulent time during the time of the instant offenses. Around the time of the first offense, his mother filed to relinquish her parental rights, and those proceedings were ongoing in family court, and she has her own mental health conditions. He was then at Rikers for 2 months, and then when he pled guilty to the first offense, was placed in foster care in the Bronx, a borough which was not his home, and placed in a special education school. Then he was, through no fault of his own, relocated to a different borough, placed in a different school, at a different stranger's home, and started working part-time at a Marshall's department store.
Counsel, would a valid waiver of the right to appeal foreclose our consideration of the YO issue?
No, Your Honor. Under Rudolph, as well as this court's decision in Cologne, as well as Pascherelli, I believe, Pascheril, which is a Court of Appeals decision, YO adjudication can be substituted for both or one or the other of Jaquan's convictions without consideration of the appeal waiver.
So going back to the issue of YO, was there a history of violence here? Fighting, aggressive behavior?
Yes, Your Honor. Yes, but at this time in Jaquan's life, he had no time to learn from the first mistake from his first offense, no time to stabilize, no time to adjust, to rely on the guidance or experience of any adult in his life. There was just simply no time. So for an 8.5-year sentence for a 17-year-old to be the result of those poor decisions at this extremely, short period in his life is unjust.
But when the court had to consider the gravity of the second offense, where he took a box cutter and for all intents and purposes, miraculously didn't kill his victim. I mean, I understand there's adjustments from the first offense when they were jumping over the bodega area and stole the money and whatever took place there. And let's say, okay, that was a year before. He was given an opportunity with family rising. He was given a tremendous gift under these circumstances, and I'm not making light of all your background concerns and issues. but the second offense is markedly greater than the first offense.
The alleged facts, perhaps, but the facts were never untested. He pled to a robbery.
I understand.
But absolutely, if Your Honor is not with me on substituting YO for both offenses, I understand, and we would ask the court to submit a YO substitution for the first offense. And there's many, many options for this court to resentence Jaquan. You can substitute for both convictions, as I said, for only one or the other, and you can pick the YO term that you feel.
What precisely did the judge say to the defendant when he took the plea on the attempt rob, what happened at the bodega, about YO if he gets into trouble again, which he then did with Batista?
He said, I believe, that he was facing the prosecutor's 3.5-year sentence.
He was told he'll get YO if he stays out of trouble.
Yes, I thought you meant on the flip side if he violated. Did that answer Your Honor's question? Doesn't seem like it.
Thank you.
Thanks.
Thank you.
Good afternoon. Jeannie Campbell, Irvin for the People. Thank you for your patience.
If you prefer to use a chair, that's permissible.
Thank you.
It's up to you.
That's okay.
The defendant didn't sign the written waiver of the right to appeal. What are the circumstances of that?
Your Honor, the defendant was not able to sign the written waiver of appeal when he appeared before Justice Satzinger on the day that he pled guilty.
He was wearing mittens, wasn't he?
I'm sorry?
He was wearing mittens, wasn't
He had the mitts, which are there's more of like oven mitts with a cinch, and generally you're shackled at the waist. So it's the entire hand that's covered, and the court officers said on the record that they could not take that situation off for him to sign. So that appears to be the only reason why the defendant's signature is not on the written waiver of appeal.
Did his counsel sign for him?
The defendant's attorney said that he had discussed the written waiver of appeal with the defendant, and the defendant's attorney's signature is on the signature line for the attorney. The defendant's signature line on the waiver of appeal is blank, and I just want to be clear on that. But our position, of course, is that the defendant's lawyer is always acting as the defendant's agent, and his representation that he discussed the written waiver of appeal with his client, plus his own signature on the waiver of appeal, does nothing to call into question the voluntariness of the waiver of appeal, especially in light of the fact that Justice Satzinger's oral colloquy with the defendant was exemplary. I believe for exactly the reasons that counsel points out in reply, that the defendant was a younger person who was going to be sentenced on his first criminal case. He made sure to be extra thorough with the colloquy, and the defendant repeatedly told Justice Satzinger that he understood throughout the entire plea colloquy and also during specifically the waiver colloquy.
Was anything else said with regard to YO other than that if you stay out of trouble, you'll get the YO or something to that effect?
Your Honor is referring to the first guilty plea?
Yeah.
That was Justice Mitchell. Justice Mitchell told the defendant that his offer to the defendant was for the defendant to plead guilty to second-degree robbery, completed, not attempted, and be given the opportunity to earn youthful offender status by staying out of trouble for 1 year and by abiding by the Families Rising foster care program, which was going to be about 6 to 9 months. If he succeeded in doing that, he would be given a youthful offender adjudication plus 3 or 5 years of probation. And if he did not succeed, he was facing being sentenced as an adult to the statutory minimum, which was the people's request, of 3.5 years in prison plus 2.5 of post-release supervision.
Did Judge Statzinger speak to the YO issue at all?
When defendant pled guilty on the second case, that was before Justice Statzinger, the parties proposed a global disposition to the court, which included no YO on either case, and the judge said that that was satisfactory, and then he took the plea. And he reiterated during that colloquy to the defendant that the agreement, which the court was endorsing, was no youthful offender adjudication on either case.
Did he explain why?
He did not explain why. There's nothing on the record at the plea about why. I mean, I think there are reasons in the record about why, but to your question, no, the judge didn't address that. But I do just want to highlight, the defense is not asking for a Rudolph remand here. That's not the relief that they're requesting. They are asking you to find that the sentencing court abused its discretion in declining to grant youthful offender status. And on this record, for the reasons that the court has mentioned and for the reasons in our brief, that's just not appropriate here.
How about as to the first incident, the bodega incident?
I'm sorry?
How about as to the bodega incident?
How what was the bodega?
How about YO as to the bodega incident? Sorry.
Thank you, I'm sorry. Well, I think that the record shows that that's what Justice Bitchell thought made sense at the time. The defendant only had the first case, right? He was given the opportunity to earn YO on that case by participating in foster care and by not committing another crime. So we opposed it at the time, but the judge thought that that was reasonable, and I can understand why. Unfortunately, and I don't dispute any of the defendant's really difficult childhood or background, I don't dispute any of that, but unfortunately, less than 2 months after pleading guilty to second-degree robbery, he committed an extremely vicious first-degree robbery. And the defendant allocated to causing serious physical injury during his plea allocution to the second case. And I know that my adversary says that the sex crimes allegations are untested, and he was indicted for those, which means 12 or more grand jurors found a reasonable cause to believe that he committed those crimes. And the motion court reviewed the grand jury minutes and found them to be sufficient. So to say that there's no evidence of the sexual element of the first-degree robbery is untrue. And I want to make sure to emphasize that. If the court has no other questions for the reasons in our brief, we respectfully ask that you affirm.
Thank you.
Thank you. Sorry. I'm still getting the hang of this, so.
Take your time.
Say no rebuttal.
You asked for 1 minute. Didn't you ask for 1 minute?
Sorry, I was not mic'd when I said no rebuttal. Thank you, Your Honor.
Oh, I'm sorry.
Unless Your Honors
Oh, is
have
that what
further
you just said?
questions.
I didn't realize it. Oh, okay, thank you
Yes,
very
I just
much.
didn't want to,
Thank you. Thank you both.
thank you.
$1,700 York Avenue against New York State DHCR, 160 East 84th Street against New York State DHCR, 87th Street Sherry Associates against New York State DHCR, Claremont York against New York State DHCR.
Good afternoon, Your Honors. May it please the court, my name is Jillian Bittner, and I represent the appellant's landlords. I am well aware that this court...
This issue has been before this court before.
Yes, it has, Your Honor, and...
So there was a motion made for leave to appeal on one of those cases, am I correct?
Yes, Your Honor.
And do you know what the result of that motion was?
I'm unsure if that motion was yet decided. I could be wrong. I am aware that this court has already issued decisions affirming DHCR's nullification of the luxury deregulation orders, but I do want to draw this court's attention to two of the appeals before it today, 160 East 84th Street and Claremont, York, which present distinct issues. These two proceedings stem from DHCR's misprocessing of the 2016 deregulation petitions. In these two instances, the luxury deregulation orders were required to issue when the tenant's leases in effect would have expired in 2017. However, this did not occur. DHCR elected to deviate from the mandatory steps articulated in former rent stabilization law 26504.3. Specifically, in 160 East 84th Street, the tenant admitted an income exceeding the deregulation threshold, and the petitioner filed its petition May 5th, 2016. Pursuant to the statute, a decision was required to issue on May 5th, 2016. A decision was required to issue by June 5th, 2016.
You're saying the DHCR was late? Is that your argument, that they were late in their responses to you?
In two of
And
the
the
appeals,
delay caused you not to meet the standard?
I'm saying that in the two specific appeals, DHCR failed to comply with the statute that dictates the processing timeline, and based upon that failure, unfortunately, the enactment of the HSTPA and
For that failure, doesn't there have to be some sort of deliberate action on the part of DHCR?
while the
You're saying they failed to meet the standard, whether they delayed or whatever happened. Doesn't there have to be some deliberate action on their part for us to find against them in this instance?
The Supreme Court found that DHCR's delay wasn't negligent or willful. However, I would like to point, Your Honor, to a decision that you concurred in 2018, Lenox Hills Apartments, Inc. versus DHCR, where DHCR misprocessed a luxury deregulation petition under the wrong statutory provision, which is identical to what DHCR did in 160 East 84th Street. It was supposed to process the petition based upon the tenant's admission of income, and it didn't. And that's exactly what happened in 160 East 84th Street. I also would like to direct the court to the Court of Appeals decision in Classic Realty versus DHCR, where the court said that DHCR had absolutely no discretion in processing luxury deregulation petitions. DHCR could not deny luxury deregulation once the income was verified. On appeal, DHCR contends that its processing deadline should have been objected to by appellant while the proceedings were still before the rent administrator. However, that's misguided. A mandamus proceeding would have taken time to work its way through the courts, and DHCR shouldn't have to rely on appellant to object to its misprocessing.
But counsel, let's just go back to the law. In order to vacate a administrative decision on the basis that you're espousing, you have to show either deliberate or negligent delay. So I want to understand, what is the deliberate or negligent delay in the record? Obviously, it took longer than it should have, and it comes to no surprise to anyone on this panel, and probably anyone who's seen those kinds of cases before. So what is the deliberate delay or the negligent delay?
So when the appellant filed, we'll use 160th as an example because I know that there's multiple appeals before you. The tenant admitted the income above the threshold in 2016. The statute, former Rent Stabilization Law 26504.3b, is mandatory. It's not discretionary or advisory. It has the language shall in it. It required DHCR within 30 days of the filing of the petition to issue an order based upon the tenant's admission. DHCR's
So are you arguing that there's an inference of a deliberate delay there?
I think that it's on its face evidence of, at a minimum, negligence to process it. It took over 2 years.
What was the reason for the delay in processing it? Because you just claimed that there was another case that was similar. The facts sound dissimilar to this.
No. So in the other case, which this court decided, Lenox Hill, DHCR had misprocessed the same exact thing.
So is there any allegation of misprocessing?
Yes. The DHCR processed the petitions under another section, 26504.3c, And in the record, it says, even the decision that was issued, that the order of luxury deregulation is based upon a match with the Department of Taxation and Finance. It should have never made it to the Department of Taxation and Finance because once a tenant admits the income is over, there is no grounds in the statute to refer the case for verification. That's the exact same thing that happened in Lennox. The tenant admitted the income over the threshold. DHR still sent the petition to the Department of Taxation and Finance, and they processed it on that ground. There is no statutory authority to do that.
So presumably there was a reversal of that case, but are the facts really similar here?
They're identical. In both cases, the tenants admitted an income. In both cases, they should have been processed under 26504.3B. In both cases, they were processed under 26504.3C. Therefore, I don't see any factual or legal difference between the cases. Here, unfortunately, you have the fortuitous timing of the enactment of the HSTPA. Otherwise, this would be irrelevant.
So isn't that the distinction?
It's not the distinction because it took 2 years for the agency to issue a determination.
What were you doing? What was the petitioner? I recall being in Supreme Court and getting mandamus proceedings all the time, and essentially we stipulated those out, that the DHCR would come to a decision within a certain period of time. Why didn't the landlord take affirmative action under the circumstances?
It wasn't necessary because the order granting the deregulation, albeit on the incorrect grounds, issued May 23rd, 2018, over a year before the enactment of the HSTPA. The landlord couldn't have had that hindsight to know that because of the order issued in 2018, the lease then in effect would have expired after June 14th, 2019. There would be no way for anyone to know. So the appellant is basically being penalized for a lack of hindsight.
Thank you.
Thank you.
May it please the court, my name is Sandra Joseph and I represent DHCR, the respondent.
So I understand the global issue that's involved in all these appeals has been addressed by this court, but what about this case in which there was all this delay by DHCR in processing the application?
Well, in answer to that, the appellant actually asked DHCR to investigate the tenant's income on or about January 23rd, 2018. So therefore, DHCR sent it to DTF to verify the
But she says, unless you're contesting that the tenant conceded an income which would result in decontrol.
Well, the case cited by the appellant, Lennox Hill, actually had a little different set of facts to it. In that case, the tenant admitted they were over income, and then when we sent out the notice of rebuttal, to be able to comment on it, the tenant then said, oh, my accountant said we're not over income, and that was the reason why DHCR didn't immediately issue the order. Because the statute also requires that we send out a notice giving them, both the owner and the tenant, 30 days to comment. And that's what happened in this case, 160. We sent that out, and the owner then requested that we send it to DTF, and that was in January 2018. And so then in May...
Is that in the record, counsel?
Pardon?
Is the owner's request in the record?
Yes, it most definitely is. In my brief, I actually cite to the record, or to the return...
So what you're saying, it's not that the tenant conceded an income which takes the tenant above the vacancy decontrol amount, but that the landlord didn't accept it and said investigate it.
I have no idea why. I was perplexed myself when I found that in the record that they asked for it. But nevertheless, even if that wasn't the case, the repeal of the statutes provided that upon expiration of the lease, the apartment would be deregulated. And the June 14th date said anything that was deregulated would stay deregulated. In this case, in the case the appellate is talking about, is that the lease expired June 30th, 2019. They made no showing in the court below that we did anything negligent. And also,
Well, then what explains the delay? How would they know? Now, maybe they would be in a position to know if they're making inquiries of the agency, but what does explain the delay here?
to be quite honest, that's sometimes DHCR gets behind, sometimes DTF doesn't get back to us. There was no negligence or malice. And the Court of Appeals has found in IG second generation, where there was a 5-year delay, that unless you can show there was negligence or misconduct or was deliberate, it doesn't matter.
Would you agree that if the tenant conceded having an income which would place the tenant into decontrol?
I'm sorry.
Would you agree that if the tenant conceded in response to your inquiry that the tenant had an income which put the tenant above the requirements for continued control, that if you then didn't issue the order, that the landlord would be entitled to relief at this point, notwithstanding the HSTPA?
No, because the tenant, nobody is entitled to, as the Court of Appeals has said, to any benefits. In McCarthy, this court actually found that where an application was put in 1989 and DHCR didn't decide it until 1997, that it was still, the owner was not entitled to the deference, to the new regulation. It still, what am I trying to say? I'm trying to say that it doesn't divest DHCR of its jurisdiction, and the owner or the tenant, either party, isn't entitled to the benefit of any regulation or statute.
You mean if in 2016 the tenant conceded an income which would take the tenant out of rent stabilization, and you did nothing about that for 2 or 3 years?
No, we did, because the owner in this particular case, and it's in the record, asked us to investigate the tenant's income.
I understand that's your position, but I'm saying, what if the owner hadn't done that? You get the application, the tenant concedes the rent, and you take no action on it.
Well, it goes through.
Is your answer the same?
It actually goes through a processing. It isn't negligent and it isn't deliberate. It's the processing of the applications at that time.
So nonfeasance in this context can't be considered negligent?
No. I mean, the Court of Appeals has found that in IG second generation, that even though it took 5 years to process an application and there was prejudice, they still found that it wasn't negligent or deliberate.
Thank you.
Thank you.
I just want to point out that page 71 of the record in 160 East 84th Street contains the tenant's income certification form, wherein the tenant checked the box that their annual...
Is counsel correct that then the tenant then disputed that statement?
No, the tenant never disputed that. What happened is...
But counsel says that the landlord told DHCR to check it out with finance.
Sure. So on page 71 on the record, the tenant completed the income certification form attesting to the income above the threshold. DHCR then allegedly sent requests to the owner, which in the record and in my brief, I know were never received by the owner or counsel on its behalf. I'm counsel on their behalf, and I never received those. The DHCR did ultimately request additional information that was received by the owner, at which time the owner said, The statute directs you to do what you need to do, adhere with the statute, and proceed. That,
So are those correspondence suggestive that they weren't negligent, that they were attempting, maybe perhaps not with the dispatch you would have liked, but they were attempting to follow up on this matter and reach whatever result or verify whatever piece of information they needed to do so to facilitate the application?
there was nothing to verify, which shows that it was negligence on its face. The statute provides that where a tenant certifies their income is in excess of the deregulation income threshold, and upon filing of such certification with the division shall, within 30 days after the filing, issue an order.
So your view is this was basically a ministerial act?
Yes, and that there's no discretion and that the statute doesn't provide for it, because if you look at the plain language of the statute, it says shall. There's very clear timelines.
So I'm sorry, if that's what the statute says, why did the landlord or the landlord's law firm make requests of DHCR to further investigate?
You mean when it received a request from DHR?
That's right.
I mean, I think right now, we're all talking about this in terms of hindsight. Again,
No, but we're talking about negligence. That's what we're talking about, either deliberate or negligence. And we're trying to figure out whether or not DHCR was negligent, or maybe the landlord was complicit in creating the situation by suggesting an investigation.
I don't think you can attribute that to the owner, though. I think at the time, the appellant wanted this process. They were trying to direct DHR to do to take whatever steps were necessary. Granted, I do understand your point that they should have said the tenant had already admitted the income. Why are you sending this back to us?
Did the tenant thereafter back off of that and say, well, no?
No. The tenant never withdrew or took back their admission of the income. In fact, even if they did, DTF, the Department of Taxation and Finance, because DHR incorrectly sent the tenant's tax information for verification, DTF verified that the tenant's income was in fact over the threshold. Basically, the issue is now, at the end of the day, even though DHR got it right at the end, the order issued on May 23rd, 2018, at which time the lease in effect expired in 2019. Had it been issued earlier, the lease expired in August of 2017, and we wouldn't be here because the HSTPA would not be at issue.
Thank you.
Thank you.
Thank you both. People versus Andrew Kaforji.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender, on behalf of Mr. Kuforiji. The search of the car at the scene of the stop in this case was unlawful under the Marijuana Regulation and Taxation Act. The hearing court found in this case that the search was lawful based upon the smell of marijuana.
So you're asking for a retroactive application, is that right?
Yes, in accordance with the plain terms of the statute.
Isn't there case law that we've rejected that?
There is. I acknowledge that this court has on previous occasions.
Well, then why don't you move on with your next argument?
Well, I would respectfully urge this particular panel to reconsider that prior precedent in light of the plain and unambiguous language of the statute. But I'm happy to move on to the other issue in this case if Your Honor would like me to do so. So apart from the issue of the retroactivity of the Marijuana Regulation and Taxation Act, in this case, trial counsel was ineffective for failing to move to reopen the suppression hearing based on the trial testimony of Officer Cristiano. At the suppression hearing, one police officer, Sergeant Rodriguez, said that Mr. Kuforiji did not signal when pulling out of the parking spot. The suppression court credited and relied upon that testimony to uphold the car stop.
So you're referring to the fact that when he's asked, did you personally observe Mr. Kuforiji engage in any suspicious or illegal activity, he says, no, I did not. Wasn't it Sergeant Rodriguez who was telling Police Officer Cristiano to do the following? And the fact that Police Officer Cristiano doesn't see whatever there was to be seen, if Sergeant Rodriguez saw it, that would be enough, wouldn't it?
Well, I think if you read Officer Cristiano's trial testimony in full, it shows that he was essentially sitting side by side next to Sergeant Rodriguez for about a minute before Mr. Kufuiji pulled off. And Officer Cristiano was quite clear at trial that he kept the car under observation, and during that time, he didn't see any suspicious or illegal.
You know, if Cristiano's knowledge is supposed to be identical to that of Sergeant Rodriguez here, I mean, there's no question, or maybe you say that there is, that this car, which had Massachusetts license plates on it, the car and the license plates didn't match, right?
That's correct, but the hearing court in this case upheld the legality of the car stop based on the failure to signal when pulling out of the parking spot, and you'll see that very clearly on pages 324 and 25 of the hearing transcript, where
But obviously, Officer Cristiano, if he was seeing everything that there was to be seen, saw something which was at least suspicious activity, in that you've got license plates belonging to an Infiniti and not on a Volkswagen. So this question is hardly constitutes this, oh, there's something here that warrants reopening the hearing, because there's this stark contradiction to what Sergeant Rodriguez is telling us.
No, I think Officer Cristiano did not say anything about the license plate mismatch. I think the prosecutor tried to elicit something from Officer Cristiano in regards to what prompted them to follow the car. And I think Officer Cristiano's statement that he did not see any suspicious or illegal activity plainly contradicts what Sergeant Rodriguez had said at the hearing, in particular, Rodriguez's claim that Mr. Kufuiji did not signal when he pulled out of the parking spot. And again, that the failure to signal rather than license plate mismatch was the basis upon which the suppression court upheld the car stop. So trial counsel at that juncture, in light of Officer Cristiano's testimony, should have moved to reopen the suppression hearing.
Shouldn't you, counsel, have made a 440 motion on this as opposed to making the argument here requiring us to maybe draw inferences that are not in the record?
No, because I think this case is on all fours with a prior decision of this court, People v. Kendall, which I cite in both my opening and reply brief, in which this court on direct appeal said that the record was sufficient to establish that trial counsel was ineffective for failing to move to reopen the suppression hearing. There, as here, there was a contradiction between the hearing testimony adduced by the prosecution and the trial testimony presented by the prosecution on a specific issue upon which the suppression court had sort of ruled upon and used to determine the legality of the police conduct. So I think Kendall demonstrates that this kind of claim, as in this case, is reviewable on direct appeal without a 440 motion. And Your Honor, if I may briefly note on the MRTA issue, I would note that the Court of Appeals has granted leave in People v. Pastrana, which is one of the cases decided by this court earlier in the spring, rejecting the retroactive application of the MRTA. So I think at the minimum, it would be prudent for this court to hold this case to see what the Court of Appeals says about that retroactivity issue before issuing the decision here.
Good afternoon, Your Honors. Carl Dubel for the People. May it please the Court. As far as the ineffective assistance of counsel issue, there was not a direct contradiction between the two officers' testimonies, the suppression testimony and the trial testimony. While the sergeant said that he observed that the defendant did not use his signal to turn away from the curb, the officer at trial, the other officer at trial, was never specifically asked whether he saw that action, and he never said, yes, defendant used his signal. So there is no direct contradiction between the two types of testimonies. Whereas in the case that counsel cites Kendall, the suppression testimony was that the bag that was searched was on the ground and it was open, whereas the trial testimony in that case, another officer said the bag was in the defendant's hands and it was closed. Those two clearly are not. Those two are clear direct contradictions, which in this case, there is no contradiction. And even if there was, to get to Your Honor's point about the license plates, the court would never have reopened this suppression hearing because there were two bases for the traffic stop. The court said on page 324 of the suppression hearing, once the officer learned that the license plate did not match the car, he had the requisite level of suspicion to stop the car. So even if counsel had objected as defendant wants, and we had gone back for a suppression hearing, the result would have been the same. Unless Your Honors have any questions about the ineffective assistance of counsel issue or the suppression issue, we will rest on our brief.
Thank you.
Thanks.
Just briefly, Your Honors, I would disagree with respondents' suggestion that there was no contradiction between the officer.
I'm sorry, counsel, could you address your adversary's point that in fact the Supreme Court did have an alternative basis in the denial of the motion, namely the issue raised by my colleague with respect to the license of the car?
So the answer is no, because on page 324 of the hearing transcript, the court sort of recognized that there was a license plate mismatch, but the court specifically said that the sergeant did not stop the car or go after the car, nor did he approach the defendant or the car at that time or for those reasons. Instead, the court found that the police approached the car only after the alleged failure to signal, and the language of the court said that provided the sergeant with the valid legal justification to pull over the car. So the court was quite explicit in finding that the license plate issue was not the basis for the car stop, rather it was a failure to signal. And at trial, when the prosecution evidently attempted to elicit that traffic infraction from Officer Cristiano simply did not cooperate with the prosecutor. Now, the prosecutor asked him on page 232, now, why did you follow his car? After counsel objected, the prosecutor asked more pointedly, did you personally observe Mr. Kufuoriji engage in any suspicious or illegal activity? That question was plainly intended to elicit the traffic infraction, but in response, Officer Cristiano said, no, I did not. So that was a plain contradiction of what Sergeant Rodriguez had claimed at the suppression hearing, which was that Mr. Kufuoriji did not signal.
You didn't follow it up on cross-examination and say, did you observe him move without signaling?
Counsel did not specifically cross-examine Officer Cristiano about that, but I think that demonstrated that counsel didn't realize that there was a contradiction that warranted reopening the suppression hearing. So for that reason, I would ask that this court remit the case for a reopened suppression hearing, but again, on the MRTA issue, because the Court of Appeals has granted leave, I think it would be prudent for this court to potentially hold this case while the Court of Appeals issues its decision in Pastrana. Thank you very much.
Thank you. Eccles versus Shamrock Capital.
Good afternoon, Your Honors. Just as a matter of housekeeping, my name is Evan Bola from Harris St. Laurent. With me today is Nevin Gertz from Bartlett Beck, who's sought to argue this pro hoc vice today. We would ask the court's permission.
Has this application been made?
Yes, it's already been. There should be a letter at the file, Your Honor.
Okay. I will grant it despite the fact that we have thousands of great New York lawyers.
Well, they've been nice enough to keep us involved, so.
Okay.
Good afternoon, Your Honors. May I lower my mask?
Yes.
Thank you. Your Honors, Mark Kirsch, Gibson, Dunn, and Crutcher for the FanDuel defendants. With your permission, I'll address the choice of law question, and Ms. Merkel, to my left, representing the KKR and Shamrock appellants, will address the New York law issue.
And you asked for?
5 minutes, Your Honor.
5 minutes on this.
Thank you. Your Honors, it's entirely consistent with New York law to apply the internal affairs doctrine to breach of fiduciary duty claims against former directors, officers, and shareholders for conduct occurring during their service.
How do you address cases like Culligan, for example, which may be interpreted in different ways?
Your Honor, in Culligan, this court declined to apply the doctrine only to defendants who had never been directors, officers, and shareholders, but did apply the doctrine to both current and former director defendants.
And does that appear from the opinion, or is that based on looking at the briefs, as you point out in your papers? So it requires some digging to get to that point.
As to the first point, Your Honor, it should appear from the face of the opinion that the 6 to whom it was not applied were all third-party advisors, lenders. If one goes to the underlying trial court opinion and the complaint, one will see that there are another dozen alleged breach of fiduciary duty parties who are directors and officers, and it was upheld as to them. Now, Your Honor, without the application of the doctrine's animating principles, which are predictability, consistency, fairness, comedy, they're undermined. State and foreign corporation laws, as you'll know, vary a lot. Those who own and manage a corporation must know what body of law guides their conduct and the standards by which that conduct will be judged later, and then so they can conform their behavior accordingly. And this would include to whom one actually owes duties, how those duties should be exercised, and how judgments made in the course of those duties will be evaluated. If the doctrine isn't applied to formers, if what law turns on what may be random events that end service, there can't be settled expectations. Unfairly, confusion about what constitutes correct behavior will be the order of the day, and foreign jurisdictions are much less likely to extend comity to disputes where New York law should govern. Now, the trial court at Record 2829 concluded the claims here are ones that should be covered by the doctrine. We agree. And also concluded at Record 29 that if a defendant group includes both current and formers, the doctrine should apply. We agree again. What's at issue here is the trial court's conclusion that if directors, officers, and shareholders are all formers, then the doctrine doesn't apply. Now, respectfully, we don't believe that's consistent with New York law, and it's also contrary to every purpose the doctrine is intended to serve. Now, the fact pattern here is a textbook example of why it's not sensible to decline to apply the doctrine to a group of formers. The complaint alleges breach of fiduciary duty against various directors. One such defendant, Matt King, was director and CEO at the time of his alleged breach. You can see that at Record 466. He was still a director and officer at the time the motion to dismiss was fully submitted in August 2020, and still a director and officer at the time the argument was held in November 2020. But 14 months later, January 22, when the decision comes down, he's no longer, it's undisputed, no longer a director and officer. The doctrine's application shouldn't turn on such unknowns as the timing of a decision. And when such vagaries are determinative, directors, officers, and shareholders can't know the precise standards by which they'll be judged and can't be sure whether conformance with what ends up being a moving target will actually protect them. And it also is important, it also, respectfully, it also undermines counsel who have to advise board members on their duties under applicable law and how to carry out those duties when they're considering a contemplated transaction. I mean, this can't be in anyone's interest. Now, contrary to Appellee's assertion, we've talked about Culligan, but New York law does support the doctrine's application to formers Your honors will see in Hart versus GM, where the suit was about GM paying off Ross Perot to resign his directorship, and both moved to dismiss the case. This court applied the internal affairs doctrine to Perot, even though he was a former director. And New Greenwich, which respondents cite frequently, same as Culligan. The court declined to apply the doctrine because none of the defendants were directors, officers, and shareholders. Now, respectfully, finally, the doctrine's application to formers has the salutary effect of devaluing the kind of gamesmanship that occurred here. The caption lists 139 plaintiffs, alphabetically, except for 5. The founders, who were listed first, who elected to incorporate FanDuel under Scott's law, who throughout all the years prior to the transactions at issue, never chose to reincorporate elsewhere. And may I just take a moment to finish? Thank you. And after the transactions at issue, sued in Scotland, although 2 of them lived in New York and 1 in California, as they themselves alleged on the face of their Scots petition, your honors can see at record 707. That lawsuit was extant for 16 months, and then presumably the founders decided they didn't like their chances in Scotland. So they abandoned that suit, refiled here with 134 other plaintiffs, the majority of whom themselves allege that they live in the UK. If plaintiffs know all they have to do is wait until a director, officer, or shareholder becomes a former, or wait until they're all formers, then calculated forum shopping will undermine every benefit the internal affairs doctrine is meant to confer. Accordingly, we respectfully request this court hold that Scott's law applies.
Let me just quickly, I know because your time is up, turn your attention to another issue. How about the aiding and abetting cause of action? What laws should apply to determining how that's to be treated?
Same laws for the alleged primary violators, Your Honor. A couple of reasons for that. One is, for example, the KKR and Shamrock appellants, almost all of them were shareholders, so same principle. But even for those who were not, the aiding and abetting, of course, is entirely derivative of the alleged primary violation. The policy would apply equally. And for the FanDuel defendants in particular, most of the corporate entities there were just created in the course of effectuating the transaction. There's nothing independent. So it should all of them should be covered.
Can I just ask you a question and go back to Culligan? In Culligan and in New Greenwich, you said that it talks about the internal affairs doctrine applying to current officers.
They do use the word current, absolutely, but that's not what they actually
officers,
do.
Current officers, directors, and shareholders. So my question is, was that dictum in that case? In other words, did those cases have to distinguish between the current and the former directors? Because it seems that in New Greenwich, the defendants were outside administrators and auditors, and in Culligan, the relevant defendants were a number of other people who were not the ones who were referred to. So I'm just curious.
Your Honor is correct that in New Greenwich, they were not called upon to distinguish between current and formers because the defendants there were never wers. They had not been directors, officers, shareholders. You're correct. In Culligan, you're right again that those to whom it was not applied were not directors, officers, and shareholders. But the court did make a volitional decision to apply it to formers in that case.
I don't know that
Current
there
and
was a
formers.
distinction that had to be made. But anyway, you could think about that.
Thank you very much, Your Honor. And I'll turn it over to Ms. Merkel. Thank you.
Counsel, you have 3 minutes.
Thank you. Good afternoon, Your Honors, and may it please the Court, I'm Ellison Merkel, and I'll be addressing the issues of New York law raised in both of appellants' briefs. Even assuming this Court decides to uphold the application of New York law in this case, the Supreme Court's decision under that law should be reversed because the plaintiff appellees failed to state a claim under New York law for breach of fiduciary duty or aiding and abetting a breach of fiduciary duty. Their claims are foreclosed because they do not and cannot allege that FanDuel's 2018 merger with another British gaming company, Paddy Power Betfair, was anything other than an arm's-length transaction negotiated with a third party. The complaint alleges that Paddy Power Betfair made an offer for FanDuel that laid out a specific price that was being offered, that the shareholders with a drag-along right accepted that offer and were entitled to accept it, and that the board then ran the waterfall at the level established by that offer. So these facts left the board with no choice about what to do. With an offer from an arm's-length counterparty that had been accepted by dragging shareholders, the board had no discretion under the Articles of Association to substitute some alternative value.
Were the defendants playing fast and loose with the valuation of the company?
No, Your Honor, I don't think that's been alleged here. The only thing that's been alleged is essentially a conclusory allegation that they disagree with the valuation.
But isn't that the claim? And as a result, the common shares essentially were worthless?
Well, the common shares were worthless because the waterfall that was agreed upon ex ante that was laid out in the Articles of Association said preferred shareholders get paid this amount in advance. They went out to the market, they negotiated in good faith at arm's length with the market, and that was the value that the market would yield. And so essentially what their case comes down to is an argument that the board should have taken the value that was accepted from the market and then done a revaluation and use this alternative value to run the waterfall at some higher level. And, you know, setting aside whether that itself might have been a breach of fiduciary duty, the Articles of Association we submit don't permit that. They said that the offer capital O that was accepted by the dragging shareholders is what gets run through the waterfall. Since that offer was less than the threshold value for preferred shareholders, the outcome was as what happened.
What if they had valued the shares of Panda at $1 each? Would someone have had an obligation then to question the valuation?
Potentially. I mean, I think, you know, it depends on whether they had valued that because of an arm's length negotiation with, you know, a counterparty in the market, or if they had then independently run some internal only valuation and valued the shares. It's sort of a counterfactual to what we have here, where you have a good faith transaction in the market. There's no coercion or collusion with Paddy Power Betfair that's been alleged. The market would bear a specific price. And so if they then negotiated, let's say they negotiated the price that they did negotiate, they then revalued it and said, let's assign $1 a share to it and then run it through the waterfall, that would have been objectionable. But here you have the best evidence of what the value of the company really was, and that's the value that was negotiated at an arm's length, in an arm's length transaction with a third party. And if I may just briefly conclude, Your Honors, we submit as well that they have not alleged the elements of aiding and abetting that underlying breach of fiduciary duty under New York law. The only substantial assistance that we see here is the negotiation at arm's length with a third-party counterparty, and there's simply no allegation, nor was there a finding in the trial court of any actual knowledge of fiduciary duty that ran to shareholders in this case. And so for those reasons and the ones set forth in our brief, we would ask you to overturn the lower court's decision. Thank you.
May it please the court, Nevin Gewurtz on behalf of respondents. This is a case about a scheme orchestrated by appellants right here in New York to steal shares worth billions of dollars from my clients, the founders and common shareholders of FanDuel. Appellants try and avoid the application of New York law by hiding behind the so-called Internal Affairs Doctrine. But as recognized in this court's precedent, the Internal Affairs Doctrine applies to current officers, directors, and shareholders.
Counsel, I understand you make that argument, and you make that argument often in your papers, but isn't your adversary's point well taken that we should interpret, really the Supreme Court, Edgar, to mean current officers or directors at the time of the events? Otherwise, you're going to have inconsistent decisions. Parties will not know what law applies, depending on when people resign, when lawsuits are brought, et cetera, et cetera.
A number of points, Your Honor. First, the Internal Affairs Doctrine, as articulated in Edgar by the United States Supreme Court, uses the term current officers and directors for a reason. The choice of law principle is applied at the time of litigation, and the question is the court going to be interfering with the ongoing affairs of the company? Here, there's no concern that the court might interfere with the ongoing affairs of the company because FanDuel Limited no longer exists. As of the time of the merger, all the share capital was removed out of it. The directors pursuant to their scheme became formers, including Matt King. Matt King was a current director of a different company as of the time of this lawsuit. That was FanDuel Group.
But how do you expect this rule to work that you're advocating for? Some of the directors are going to be held to one standard, and different directors are to be held to a different standard, probably all regarding the same issue?
Sure. Your Honor, I think that's a different case than the present case. And certainly there are hypotheticals where we can get into that, where the court would need to consider that under New York's broader interest analysis, which appellants concede is the overarching principle that applies here. I think when you think about the notions of predictability, New York has handled those policy considerations under its broader interest analysis. Applying an interest analysis to tort law claims, such as fiduciary breach, implies that there are going to be instances where having New York law or the law of the forum where the tort occurred is going to apply regardless of the predictability. So I think the New York Court of Appeals has already addressed these policy concerns, and New York courts say under the interest analysis that the internal affairs doctrine is but one factor that is to be considered in this broader analysis. And to that point, I'd like to raise one item that was raised in the reply brief of respondents. There are several New York cases that apply the interest analysis and say New York law applies in light of the internal affairs doctrines to former directors. Most notably is the Tyco case, which is cited on page 32 of respondents' briefs. It's found at 756 F sub 2nd 553. Tyco is a case where the Southern District of New York applied the New York interest analysis and found that New York law applied instead of Bermuda law, where Tyco's state of incorporation. The claim was that the former CEO, Dennis Kozlowski, breached his fiduciary duties while he was a current CEO, but at the time of the lawsuit, he was a former. So the principle outlined in Tyco is the same as this court's precedent regarding that at the time of the lawsuit, if the directors are former directors and there's no risk of interfering with the ongoing affairs of a company, then the internal affairs doctrine does not apply. That's distinguishable from Hart, Mason Mahone, other cases that appellants cite in the sense that Hart dealt with General Motors, definitely an ongoing affair there, and Mason Mahone dealt with the HSBC Bank, also a company that continues on to this day. So those cases concern situations in when the company's ongoing and the court is saying, I don't want to interfere with the ongoing internal affairs of those companies.
Sir, I'm sorry, I mean, there's been a little overlap here between Justice Singh and Justice Friedman's question, but your friend identified a number of benefits to the rule that he proposes, which is the internal affairs doctrine applies to both current and former directors, shareholders, et cetera. We look to the office they held or their status at the time of the events giving rise to the litigation to determine whether the doctrine is going to apply. He identifies consistency and uniformity in the law, the predictability of outcomes for the actors involved, ultimately in fairness, and then outside of our borders, comedy. What benefits can you identify for the rule that you're proposing us to adopt?
Or a number, and those benefits are articulated in Leachy in terms of New York's interest analysis and what New York courts do when they're applying their choice of law rule, which is to say that the state with the greatest, most significant interest to the location of the occurrence of the tort should have its law govern. And there are a number of reasons that the court gives, and the Court of Appeals in the cited cases below give in that case as to why New York has chosen to give preference to the location in which the tort occurs. And despite the arguments about Scott's law, if you look closely at appellant's brief, their arguments as to what interest Scotland may have to counterbalance this interest analysis really only lies on the location of non-parties. And in fact, New York law is that it is the location of the occurrence of the tort that is paramount. And there is no dispute that that location is here in New York.
I'm sorry, go ahead.
I was just going to ask you, in this case, doesn't the record reflect, in fact, when the meetings occurred, when they were making certain discussions with respect to distributions, that they were looking to the British companies law in making those determinations?
I'm sorry, Your Honor, with regard to the Board of Directors vote on 699, is that what your question is, Frank? The FanDuel Limited was incorporated in Scotland. We don't dispute that. And it is true that in the Board of Directors meeting, there were two critical votes, one on whether the merger should occur, and one on how the distribution should be made. With respect to both votes, the Board of Directors meeting minutes say, contrary to appellant's statements in their brief, that the directors have fiduciary obligations to the common shareholders for the benefit of the members as a whole under the Companies Act of 2006, which was Scots law, which was what FanDuel Limited was incorporated in. Our point is that the breaches of fiduciary duties are occurred here in New York, and under the law of New York, the interest analysis that is done, as well as this court's precedent that simply states that when the situation is that former directors are involved in a lawsuit that doesn't jeopardize the ongoing affairs of a company, that New York law applies. But if Scots law applies, we believe we have very viable claims as well because we don't see a distinction. One last point, Your Honor, and then I will cede my time, obviously, since I'm done. In terms of the consistency of judgment that Your Honor mentioned, Edgar is very clear on this point. This is a point that relates to when multiple cases are going on.
But Edgar respectfully cites to the restatement of conflicts, and if you look at the cases in the subsections, they seem to suggest, they seem to apply both to current and former. And as an aside, what was the issue in Edgar's? Did it concern the issues that we're discussing now? Or was it just a statement?
Edgar is actually a Commerce Clause challenge to extra state jurisdiction in an Illinois statute.
But really nothing to do with the issues of internal affairs.
I think Hart is actually your own court's precedent, and Hart is an instance where there were multiple cases going forward, both in Delaware and in New York. And so when the court discusses the inconsistency of judgments, it's referring to the notion that, is there going to be another court ruling on this exact same thing at this time? And of course, that is not present here.
Well, but in this case, there's going to be an inconsistency, or there could potentially be an inconsistency of judgment between, for example, the person who just left and now is a former versus current, et cetera. That does seem to raise some.
Again, we would dispute that Matt King is a current at any time in this lawsuit. He was always a former. The company that was incorporated in Scotland no longer exists. Pursuant to the scheme that is alleged in the complaint, all of the shares in that company were taken out of the company. All of my clients' interests were removed, and the shares that the company actually received in Pandico, which were the shares that required to be valued, were quickly shepherded off into companies that are actually headquartered here in New York, actually just down the street, 1375 Broadway.
If we didn't apply the rule your friend is advocating for, would that have and therefore that we say it's limited to the current, meaning as of this moment or at the moment of the action was commenced, whatever the appropriate red letter date we would use, would that have a potential chilling effect on individuals' willingness to serve on boards or to serve as officers of corporations or to purchase stock?
We don't believe so. I don't think there would be any chilling effect that would occur. I think you can look no further than this case. I think this is an instance where the acts that were perpetrated were done knowing that the individuals would become former directors. They were done here in New York. They knew very well that by doing what they were doing, they were removing the shares of the company, they were extinguishing the company. And I think if you look across the landscape, both federal and court cases, whether it's Tyco or Drennis or UBS Securities or Culligan or New Greenwich, when you have situations like this where you have fiduciaries removing the value of the company for themselves, New York courts apply New York law.
Thank you.
Thank you.
Very briefly, Your Honors. I think my friend referred to the so-called internal affairs doctrine. There's nothing so-called about it. It's been in existence and applied for many years. My friend also talked about the doctrine really having to do with interference with the ongoing affairs of the company. I think it should be apparent that the underlying principled basis of the doctrine is to provide guidance ex ante to directors, officers, and shareholders, particularly, I think, directors who have to make fundamental decisions about the company in the interest of all the stakeholders, depending on what the local law says those interests are that the directors are bound to protect. That should not be forgotten. Also, my friend was talking, I think, about the internal affairs doctrine as if it were merely just one element in a whole constellation of elements one considers in a forum nonconvenience analysis. That's not the case. The internal affairs doctrine, the law, I think, is made clear, presents a strong presumption. And we have not found a case where there's some other extraordinary interest so important as to outweigh the application of the internal affairs doctrine to current and informers. Finally, my friend talks about Matt King having was never a current for purposes of this lawsuit. I am puzzled by that because, as Your Honors will see from the first amended complaint, all the director defendants were alleged to breach their fiduciary duty as directors of FanDuel Limited to each of the plaintiffs, shareholders of FanDuel Limited. That is how it is postured. And therefore, Mr. King, in fact, was current, and until just before the motion to dismiss decision came down, was current. Thank you very much.
Thank you. Thank you all. People versus Juan Rivera.
Good afternoon, Your Honors, and may it please the Court. Rebecca Martin for Appellant Juan Rivera. Your Honors, we are asking that you reduce Mr. Rivera's sentence in the interest of justice for a number of reasons, but most significantly, the connection between his actions in this case and his lifelong struggle with heroin addiction. Mr. Rivera has been battling that addiction since between the ages of 16 and 20 years old, which is when he began to first start using intravenous heroin. His crimes in this case are clearly linked to a relapse, but notably prior to that relapse, he had maintained sobriety for around 5 years, and during that time, he had held down a steady job and had very, very minimal interaction with the criminal legal system. The record is unfortunately pretty light on details about what caused that relapse, but we do know that he was widowed and he was living alone, and it's pretty easy to see why in those circumstances it might unfortunately cause someone to relapse from the progress that he had made. But given this link between Mr. Rivera's actions here and his relapse, the fact that he has shown that he can be motivated to and can achieve sobriety, and that if he does so, he will contribute to society, he will work, and also considering Mr. Rivera's relatively advanced age, he is 61 years old, and the nonviolent natures of the crimes in this case, there was no purpose served in giving Mr. Rivera anything above the minimum sentence here. I would like to acknowledge that Mr. Rivera does have an extensive criminal history, but would like to emphasize that, as with the incidents in this case, his entire criminal history is linked to his lifelong struggle with addiction.
20 misdemeanors, 4 felonies, violent felonies in '86, 2005.
Yes, Your Honor, that is correct. But you can see that his first arrest was around the age of 18, which is around the same time as he began working. When he did go to our program and achieve sobriety, very little interaction with the criminal legal system. And I would also like to note that that 2005 conviction was factored into this sentence in as much as he was sentenced as a prior felon.
I mean, you've got the 2016 conviction, which takes place after his arrest in this case.
Yes, the Bronx conviction.
Attempt rob 2.
That is correct, Your Honor. I would like to say 2 things about that. First, that is still consistent with this pattern of criminal behavior being linked to a period of relapse. That was all kind of during the same period. And
Do you
second,
know
that-
what his sentence was on that case?
I do. It was, I believe it was 5 years incarceration, 6 years incarceration, I'm sorry, 6 years incarceration, 5 years PSR. And
But she's serving concurrently with this case, right?
he is, and that case has also, just for your information, is on appeal and it has been briefed.
So that we can clear it up, in this case, you're seeking to reduce his post-supervision release period from 2 years to 1.5.
That is correct, Your Honor.
And in the
And also the incarceration
and in
period.
the proceeding that my learned colleague raises, he's still under the 5-year post-supervision.
PSR, yes.
So in a sense, even if we reduce the period here because he's out on conditional release, he's still subject to the second period, correct?
He is, yes, at this time, as I said,
Which would render it moot, in a sense.
Potentially, at this point, given that that sentence is also on appeal, that case is also on appeal, we want to just focus on this case because we don't quite know what the outcome of that case is.
Right now, he's on conditional release, right?
He is on conditional release, that's correct. And I would like to emphasize that that does show that he was doing well in prison. If you don't have any other questions, then again, we are just asking that you reduce the sentence to the minimum. That is both the incarceratory portion and the PSR. Thank you.
Good afternoon again, Your Honors. May it please the Court, Carl Dubel for the people. Defendants sentenced to a reduced crime following a bargained for plea agreement in this case should not further be reduced on appeal. Defendant's criminal history shows that an above minimum sentence was warranted. He has multiple violent felony convictions, including the most recent robbery conviction in the Bronx. He also has several, I think one nonviolent felony, as well as the Department of Probation noted that he has multiple parole and probation violations, which led it to conclude that the defendant has failed to benefit from non-incarceratory sentences in the past. In this case, he also admitted that he was selling drugs for his own financial benefits. The evidence of his addiction at the time that this crime took place is not as clear as defense counsel makes it out. On page 4 of the PRS, or the PRS, it says, when asked whether he was currently using drugs, it's marked false. Also, the other mitigating factors that the defense points to, I believe, were already accounted for in this plea agreement because he was allowed to take a plea to a reduced charge. If he had pled guilty, or if he was pled guilty of what he was charged with, or if he was convicted after trial, the minimum sentence he could have gotten was 6 years. So the fact that he was able to plead to a reduced charge and get 5 in this case shows that his sentence is not excessive. And unless Your Honors have any questions, I would rely on my brief and ask that you affirm.
Thank you.
Thank you.
Your Honors, I would just like to briefly respond to the point about whether or not it was clear that Mr. Rivera had relapsed. Elsewhere in the PRS, he did say he had, so I think that one marcation didn't seem to match up to anything else. And he did say that he was selling drugs for money, but it was a very small amount of heroin, which is his drug of choice, for a very small amount of money, $30. That's pretty typical behavior for addicts, selling a little bit of drugs to continue to support their habit, which is something that this court and its sister court in the Second Department has acknowledged in the Cordish and Cowell cases, which are cited in my brief on pages 12 and 13. So I think to say that this behavior wasn't clearly linked to Mr. Rivera's addiction, I think is ignoring what is clear in the record. If you have no further questions, then I will rest on my brief.
You said the other one is up appeal. Has there a date been set for the Bronx case?
Sorry, what was that?
You said that the Bronx case was on appeal. Is there a date?
It is currently set to be calendared in November. There hasn't been a response brief yet.
Thank you. Thank you both. Tantalon Austin Hotel versus Wilmington Trust.
May it please the court. I am William Dayhill, counsel for the appellant Tantalon Austin Hotel. Respectfully, the lower court's dismissal with prejudice of the complaint in this case, based on the voluntary payment doctrine, should be reversed. The payment of a preliminary estimated amount subject to adjustment cannot be a voluntary payment of a full amount made with full knowledge of the facts and without mistake of fact or law. Therefore, the voluntary payment doctrine...
Wouldn't it have been pretty simple to just write a letter saying, hey, we object to these fees? I know you only had 4 days before, or your client had 4 days before closing to do it, but wouldn't that have been a reasonable way for the attorneys to handle this?
Your Honor, there was no reason to do that when nobody said this is what the amount due is. What was explained to the person who had spent the last year working very hard...
Didn't they say if there's a mistake, there'll be a reimbursement?
I'm sorry, excuse me, Your Honor?
Didn't they say if there's a mistake, there'll be a reimbursement?
That's right, Your Honor. What it says if their overages will be refunded. And so when my client received this...
So what does the agreement tell us about what liquidated damages are?
Are liquidated proceeding, liquid proceeds? Liquidation proceeds.
Right.
It's what the contract says that liquidation proceeds are...
Liquidation fees. Liquidation fees.
Right. Well, first off, the only place it's defined is in the pooling and services agreement, which my client didn't have. In the pooling and services agreement, it talks about liquidation proceeds being cash received. This is section 1.01, record of 108. That liquidation cash amounts received are paid to the master servicer or the special servicer in connection with the liquidation, including the payment in full of the mortgage loan of the mortgage property through, and I'm ellipsing, through a trustee sale, foreclosure sale, or otherwise. It does not say that if there's a sale of the property, there will be liquidation proceeds generated.
And how are liquidated fees generally viewed? It's liquidation as a result of foreclosure, or is it as a result of just an arm's length sale? And how are those fees generally viewed?
Well, Your Honor, by its common usage, and again, we can only use there's a common usage and there's a definition in the agreement. The agreement the only reference to sales in connection with in the contract talk about trustee sale, foreclosure sale, and things along those lines. The liquidation typically, if one were to look at Investopedia or Black's Law Dictionary, would say basically a winding up of a business that is failing, and therefore you make distributions to your creditors. What we have here is a sale of a business. It happened in the context of somebody who had to sell, but the reality is that the business wasn't terminated. The property was sold.
No insolvency, no bankruptcy, there was nothing like that.
That is correct, Your Honor. There was nothing. And in fact, the special servicer here paid no part whatsoever in the sale process. And proceeds didn't go to a special servicer, which is under the agreement. Again,
Wasn't the idea to avoid that?
It was 100% to avoid that, Your Honor. The purpose here of the sale was to avoid the necessity of getting a trustee involved, having somebody marshal assets. There was no appraisal done. There was no need to do an evaluation of what the property was. There was no need to determine whether or not what the highest and best way to sell the property to satisfy creditors was. My client went out, worked hard, found somebody who says, I'll buy your hotel, and they sold the hotel, and that was the end of the transaction. If there's nothing further on that, because I think the question here is two questions. Was there a voluntary payment? And again, our position is there will be no voluntary payment when somebody says the payment you're making is preliminary, subject to adjustment. And then the question is would it even be appropriate to have a liquidation fee charged for the liquidation proceeds? And under the plain language of the agreements, if they're at the plain language of the agreements does not support that there is a liquidation fee payable here, or again, where this was an arm's length transaction by my client without any sort of trustee or any sort of special proceeding or credit restructuring or any workout. None of that happened. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court, David Mignardi on behalf of the respondents. Your Honors.
So what's your best argument focused on the agreement that says that the plaintiff is supposed to pay a liquidation fee for something like this.
Well, Your Honor, the loan agreement specifically does reference that this loan can be pooled and serviced. In fact, that's why the terms are what they are. It references that.
And doesn't, and I'm sorry to interrupt, doesn't it also say that your adversary's client is not going to be responsible for any of the fees or expenses as a result of the securitization of the loan?
As a result of the actual pooling of the loan, it does not say that once pooled, the borrower is then cloaked from immunity of any fees. In fact, the borrower paid special servicing fees.
Of workouts, insolvency, bankruptcy, and then there's a mention or liquidation fees. It's not what you had here, is it?
Well, the liquidation proceeds are defined in the pooling and servicing agreement. My colleague just...
Which plaintiff is not a party to, right?
He's not a party to, but the servicing agreement is referenced in Section 11.24 of the loan agreement. So this sophisticated borrower was aware that this was going to be pooled, and that the trust was going to be delegating servicing duties to its servicers, and that...
You know, it's all well and good to say the sophisticated borrower. It's a good point, but all you have in the agreement, the loan agreement, is 11.13.1, and there's liquidation fees if there's bankruptcy, buyout, workout, insolvency, none of which you have here.
Your Honor, but it does also say that the borrower is charged with reimbursing cost fees for incurred in connection with the special servicing of the loan. In fact, the borrower did pay special servicing fees, which, like the liquidation fees, are also borne under the pooling and servicing agreement. So the borrower can't say, I'll pay these fees, which are due and owing under the pooling and servicing agreement,
But
and not pay these.
I'm sorry, I don't understand the argument. Isn't there a distinction between certain fees and liquidation fees? How are liquidation fees, how do they arise?
Under Section 1.1 of the pooling and servicing agreement, it says liquidation proceeds are generated when a defaulted loan is paid in full, and then it says by foreclosure sale, trustee sale, or otherwise. So it's an expansive definition, or otherwise cannot be overlooked. Anytime a defaulted loan is paid in full, liquidation proceeds are generated. A liquidation fee is
But it's not a liquidation. There was a sale here. There was no liquidation. There was no trustee. There was no bankruptcy. I don't understand the argument.
It says, Your Honor, it does say when the loan is paid in full upon foreclosure sale, trustee sale, or otherwise. So
I don't know, what does or otherwise mean? I mean, not that we have to get into it at this stage of the litigation.
Your Honor, I think it's an expansive definition. Whenever a defaulted loan, which is the case here, there's admitted default. Whenever it's paid in full.
Wouldn't you think that contemplates where there's a trustee sale or foreclosure sale, not this sort of a transaction in which you're just paying off the mortgage? I mean, that there's going to be this $1 million liquidation fee when you pay, in effect, prepay the mortgage. There's nothing which gives you an inkling that that's contemplated. I mean, you know, when you talk about a foreclosure sale or a trustee sale, you've got some concept that there's some sort of proceeding which involves reason to generate fees.
Your Honor, I mean, we have to look to the definition in the agreement. The agreement says it's generated upon the payment in full of a defaulted loan or otherwise. So if it was limited specifically just to those two instances of a foreclosure sale or a trustee sale, I'd be in agreement with Your Honors. But it does say or otherwise. But I think this goes to whether the...
I hate to keep asking because it's been asked so many times, but you're saying or otherwise, but you're not really defining or otherwise.
I think, Your Honor, it's whenever a defaulted loan is paid in full, the liquidation proceeds are generated.
But that's not what it says. You could have said that quite simply if that's what you meant to say.
Well, it says or otherwise, which is pretty all-encompassing.
Okay, but let's go to really what the issue is.
The way you've just defined it, of course, it's what you could have said. You've really complicated by making these specific references, and then you say, well, or otherwise means any time you pay it off early if it's in default. Obviously, if it's in foreclosure, it's in default, and you're paying it, and it's getting paid off early. So that's...
I think, Your Honors, this does go to the request for dismissal under 3211A1, which is the documentary evidence. But the lower court did find that the voluntary payment doctrine applied here, and that the borrower, in the absence of fraud or duress,
I'm sorry. So wasn't it reasonable for the plaintiff to believe, based on the disclaimer that the payoff was subject to adjustments or a refund of overages. So wouldn't it be reasonable under those circumstances where you get these they're preliminary payoff letters 4 days before the closing to look at it, go through with the closing, and say, okay, we'll true up later?
Well, Your Honor, I would say that there's a difference between an overage should be refunded and there's an improper demand for a component of amount due and owing. An overage should be refunded typically contemplates.
Does it say that it's limited to overage?
Yes, it does. It says overages will be refunded and shortages will be recouped. It's something to that language, Your Honor. So that, when a loan is paid off, oftentimes interest is calculated for a future date. There may be overages and, you pay too much interest, here's a check back, that sort of thing. This is an improper demand. The Dram Act Realty says when you're faced with an improper demand, which is what borrower claims it is, an improper demand, you're charged with making your reservation or protest at that time and litigating the issue. You can't pay and then subsequently say, oh, I want a refund, just because it says overages will be refunded. There's a difference between a request for an improper demand and that we will refund an overage.
Why wouldn't this just be an overage? I mean, just an overpayment.
Because they're not claiming that the liquidation fee was improperly calculated. They're saying we shouldn't have been charged a liquidation fee.
So overages are just ministerial calculations.
Overages means that the amount paid was incorrect. There was a miscalculation. Here, they're saying this shouldn't have been brought to our we shouldn't have been paid this from the get-go, which is something they had full knowledge of when they received the preliminary letters, the payoff letters. So it's not something that they learned afterward. Oh, there was a miscalculation. You overcharged me by 10 grand. You should pay it back. They're saying we requested at the time the payoff letters were issued. They had full knowledge of that request for recoverability at that time. There's nothing subsequent later where they learned, oh, now I know what they mean. It was always right there out on the table that it was the $1,030,000 that was requested. So, case law that this court has issued says that is the time you're supposed to make a demand for, whether it's a protest or pay with a reservation of rights.
In this instance, it says there are 2 preliminary payoff letters. Is that important that these are preliminary payoff letters, i.e. the amounts aren't set in stone?
No, again, Your Honor, I would say that it's not, because this is not a situation where we're talking about a fluid number of.
Then why are they called preliminary payoff letters as opposed to as opposed to a payoff letter?
And that's what it's issued in. It does direct the borrower, if they are going to make payments, to call to confirm the amounts due and owing. Presumably that was done at the closing. This is a very large amount of money. Presumably they wouldn't just take this and just go with it. But again, they're charged with making a demand or making a protest before payment.
It's also called estimated.
I'm sorry, Your Honor?
It's also called estimated.
Again, but there's not an allegation here that this was a miscalculation, that we misestimated the amount of liquidation fees. They're saying that this is an improper demand from the get-go. They had full knowledge of that at the time they received these letters. So therefore, they always had full knowledge of the facts. Their knowledge never changed. It was always a liquidation fee that was requested in the same amount.
But wait a minute. If they're not a party to the PSA, how do they have full knowledge of the amounts that are demanded in the preliminary payoff letter, where you've already said that overages will be refunded?
Your Honor, they're not a party to the pooling and supervision agreement. That's correct. But again, the loan agreement does charge them with knowledge that if the loan is securitized, which it was, which they were well aware of, that.
And they also know that they're not responsible for any fees as a result of the securitization.
As a result of the actual process of the pooling, but it doesn't mean once pooled, they never have to pay. The borrower paid special servicing fees. Those are also due under the PSA. How could they pay one fee due under the PSA but not pay another?
I know it's not the issue of the appeal, but in a commercial sense, what's the justification for this liquidation fee? I understand if this goes into foreclosure, if it's a trustee sale, that sort of thing, that there are going to be fees. But what, in this type of transaction, commercially justifies the fee? Again, I understand that contractually you can agree to anything, and if that's what the contract says, too bad for the other side. But just what's the justification for this?
Your Honor, I mean, once a loan does go into default, there's a lot more obligation and responsibility on the part of the trust, and the servicer, special servicer gets involved. There's a requirement to always, keep an eye on the property. There's multiple scenarios where they have to incur more costs and incur more time and keeping an eye on an asset that is now in danger of defaulting or potentially.
Where it didn't go into foreclosure and you didn't have a trustee sale?
That's true, Your Honor. In this case, we didn't, but we can't on every loan see, okay, how far along did we go to see whether.
If you did, then there's a liquidation fee, but here you didn't.
Well, Your Honor, I would just say that the liquidation fee is plainly defined as a payment of a defaulted loan in full or otherwise.
I understand it's not a determinative issue. I just wanted to know how it fit into the story that we have here.
Understood, Your Honor.
Thank you.
Thank you.
Your Honors, it's late in the day. If there aren't any questions for me, I don't have anything to add, particularly in response to what counsel said, but I certainly want to give the opportunity, if there's issues that were raised by him that you believe I should be addressed, to assist you.
I just want to be clear on one thing, and it's unrelated to what we've discussed, is there's no contract between plaintiff and Midland, correct?
That is correct, Your Honor.
Thank you.
Thank you.
Thank you both. Cardinale versus Avalon West Chelsea.
Good afternoon. May I please the court? Ilana Schachner for the plaintiff appellant. At the core of this appeal is the question whether a 3.5-inch drop in height located at the threshold of a closed, locked door can be said to be, as a matter of law, open and obvious and not inherently dangerous.
Had your client seen this platform before?
She had been there one time previously after living in the building for several years. This was in place for approximately 5 days. She had been there under different circumstances.
So you mean she had been there 5 days, within the 5 days prior?
She had been there within the 5 days prior with one of the employees of the building who
So she was aware that it was present?
She had a general awareness that it was present.
I don't understand. What do you mean by general awareness? She didn't see it the first time she went there?
She did see it the first time she went there, but at the time of her second visit, when she was alone, she had to unlock the door. She was holding laundry bags. She had to push a heavy door forward.
Did she say in her deposition that she misjudged the height the second time when
she didn't realize the height. And the court has recognized that a plaintiff's being distracted or inattentiveness is a matter not that would completely displace the liability of the landlord to provide a safe place to live, but rather a matter of comparative negligence. And that is for a jury to decide and not dispositive of the motion for summary judgment submitted by the defendants. In this particular instance, the plaintiff is a 72-year-old woman. She is trying to maneuver both the laundry and the heavy fire door, which needs to be pushed in, and she has to use her body weight in order to push it in. She shifts her weight forward, not recalling that there was this drop down or the extent of the drop down, and subsequently falls and fractures her ankle.
Excuse me, was there any issue of lighting? Was there any issue in terms of being able to see the yellow strip at the edge?
There's actually a question whether the yellow strip existed at that time. There is vague testimony that it would have been used. There was no specific identification of the photo by the plaintiff showing the yellow strip. There was other testimony that similar types of strips were being used. Nobody could actually definitively point to a photograph showing the specific doorway, and identify both as far as place and as far as time the strip in the doorway. And again, this is not dispositive of the case. A defect can be open and obvious and still be impose liability on the defendants if it is inherently dangerous. And they had recognized that a ramp should be placed in every doorway where there is this gap in height. So even if the court were to find that there was this yellow strip, first of all, we don't have any evidence that it was visible when the door was closed. In fact, photographs of the hallway when the doors are closed do not show the yellow strip. And even if there was a yellow strip there, it does not absolve the obligation to provide a safe egress to the laundry room.
Were there any experts who measured the distance and said that the distance was too high or anything like that?
Not yet, and I do want to point out that the defendants did not either. And in order to establish their entitlement to summary judgment, they would also have to present expert evidence that this condition is not defective.
But your client is saying that the drop was lower than she thought it was. So she wasn't unaware of it. She didn't not expect it. She saw it. She knew it was there. And she thought it was a different height than she...
Not exactly. She testified that she didn't realize that the drop was there.
Well, she
never
knew it was there. I think what she said exactly was the drop was lower than I thought. The way it went on her ankle.
That was in reference to explaining the mechanism of how she fell or how the injury occurred. If she anticipated that the floor would be a continuation of the hallway, then she would not anticipate the drop in height. And she later testified also, when asked about the drop in height, she said, "I didn't realize it." She said specifically, there was a 4.5-inch difference and I didn't realize that. And again, the question here is not whether she should be apportioned some culpability, but rather whether that in itself is enough. And the First Department has found that it's not enough to completely displace the obligation of the landlord to provide a safe premises for its tenants, including the elderly or less athletic tenants.
Thank you.
Thank you.
Good afternoon. May it please the court. Joshua Jamal for respondents Avalon Bay. I don't want to belabor the issue.
Why wasn't it inherently dangerous?
I think that it's well-settled law that a single-step drop or differential in height in and of itself is not inherently dangerous without there being more. There is no duty beyond, just having a safe environment for the tenants to be in. Not every step is dangerous because somebody falls on it.
Is there an expert or anyone who's indicated that the step that existed was of the right height or?
Your Honor, there is no expert in this case. The allegation that there was a defect in the stair, the lower court pointed to the fact that the plaintiff never brought a claim that the step was defective in any manner, that there was any defective condition of the step, that the height differential was too tall or too short. This case didn't require an expert to establish that it wasn't inherently dangerous.
Or is there an issue of fact as to whether the platform had yellow safety tape on it at the time of the plaintiff's accident?
I would submit, Your Honor, that that's nothing more than a red herring in this case. There's no need to be a yellow safety strip. The fact that it was there was just a precaution that the contractor and my client had put in place. It's not required to be there. The fact that it wasn't there or was there would not change the fact that it's not inherently dangerous to have a single 3.5-inch step down. What's inescapable in this case is that the plaintiff testified clearly that prior to the accident, she was aware of this condition.
She was aware of it yellow strip or not.
And at
she was aware of it yellow strip or not. She was aware of this step.
She did not, she never testified that she was unaware of the
She
yellow
had
strip.
been there before.
She had been there before with or without the yellow strip. She knew it was there, the step down was there. She was aware of it at the moment that she was entering into that room, just before her accident. She knew there was a step down.
This claim that there should have been a ram, where is it that the ram should have been placed?
Again, another red herring. We're talking about subsequent remedial measure evidence, which may be subject to disclosure, but it's not admissible evidence, and it shouldn't be relied upon by this court in making its
The ram would have
determination.
led you up to the step, right? Would have led you up to the platform.
There was, after the accident, as a subsequent remedial measure, ramps were installed to transition down the 3.5 inches from the platform down into the room.
It's at the ends of the platform.
That's at the edge of the platform, transitioning down into the room.
So
That was
instead of a step, there was a ramp.
Right, but it was a subsequent remedial measure that was put in place after the accident and as a result of the accident. And I would submit that public policy would dictate that that should not be a subject of this appeal. If correcting something or making something more safe were only going to create liability, then landlords and property owners wouldn't correct unsafe conditions. The same thing with the safety strip or the yellow paint or the anti-slip tape. There's nothing in any case law that dictates or any statute that dictates that this be there. The fact that my client put it in place or that the contractor put it in place doesn't mean that they had any appreciation that it was that this was a dangerous condition or not a dangerous condition. It was a consideration for the safety of its tenants.
Right, well, if it were bright yellow, that would certainly support your argument even stronger, right? That if it were bright yellow, it was simply more open and obvious.
More open and obvious, correct. But again, it's not something that's required under the law, and to point to it would only establish that people shouldn't paint bright yellow safety strips, because if they do, it's only establishing that they knew this was a dangerous situation. That's not the case here. They were just taking caution, okay?
Sorry, you can finish your sentence.
Public policy dictates that you don't point to or punish people for taking measures to make things more safe.
So I just have to ask you then, was there a bright yellow tape?
There
or
absolutely
was there not?
There absolutely was bright yellow strip. There is no evidence in this case anywhere that says that there wasn't, other than the arguments in counsel's briefs. Plaintiff never denied that it was there. The contractor said it was there. The contractor said he completed this job on August 10th, 5 days before this accident, and that paint and the safety strip were there.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Justice Renwick, in response to your last question, in the record on page 451 is a page of a deposition of a leasing agent for Avalon, Ms. Kennedy, who specifically looked at a photograph and said, yes, when I accompanied Ms. Cardinale down to the basement, there was a black line and yellow paint present, and then she further clarified that the black line was friction tape that felt rough. So that was present at least 2 days before this incident occurred.
Does it matter whether it was present or not? The yellow tape.
It only, I think, makes clearer that there was a transition at this particular doorway that was open and obvious, and the combination of things made this not inherently dangerous. And the plaintiff did testify, I think, on 3 separate occasions that she was aware of the 3.5-inch drop from the temporary platform to the floor of the laundry room. I really don't have anything to add to the argument here unless there are specific questions, and I would rest on the brief.
Thank you.
To address a few of the points that were raised by my adversaries, with regard to the ramp, there was testimony by the contractor that it was understood that ramps need to be placed at all doors and all ends of the ramp. It was a necessary step. The yellow stripe, whether it was there or not, was not to replace the need for a ramp. The ramp was agreed to be needed regardless. So it's not a question of subsequent remedial measures. It's a matter of the basement being...
Based on your client's testimony as to how she felt, whether there was a ramp there or not, would that have changed anything?
I believe so. I believe that she would not have the drop in height.
She misjudged the distance, right?
No, she misjudged the height.
Or the height, excuse me.
So if there was a ramp there, there would not be a sudden transition. And again, the entirety of the circumstances have to be taken into account, and that is exactly the issue here. These are very fact-specific matters that have been determined to be appropriate for jury determination, not for decision as a matter of law. With regard to the yellow strip, there's actually photographs in the record that show the hallway with the doors closed and the yellow strips are not visible. So there is evidence that this was, considering there is no doubt that the door here was closed, there is no doubt that it would not be visible even if it were there. And again, the most...
If she had been on it, and I think that argument would be stronger if she had encountered this for the first time, but that was not so.
But that again goes to a matter of comparative negligence. The First Department has unequivocally said that the fact that the defect is either open and obvious, or the fact that it was even observed by a plaintiff.
Well, what you say is true, except that the issue becomes whether it's inherently dangerous or not.
Well, we submit
it's open and obvious, and it's dangerous. The fact that it's open and obvious leads you to comparative negligence. If it's open and obvious and not dangerous, then...
That is true, but that's a matter for the jury to decide. It's a very fact-specific matter that needs to be determined by a jury, not by a decision as a matter of law. The fact is that, you know, this was a height differential that was hidden behind a heavy door, that the surrounding facts necessitated her to lean forward, causing her to lose her balance. It was not a condition that she was accustomed to because it was present only for a matter of about a week before this occurred.
Thank you.
The surrounding circumstances, there was no additional precautions taken to prevent this or to keep the room closed until the appropriate precautions were taken.
Thank you. Thank you all.
Thank you.